Hello again. Now, in self-defense, there is it includes the defense of life, property, honor, or rights. Honor or rights, yes. This defense is or can be readily claimed by accused, even if false, but which is normally accepted. Now, this self-defense is well can be used almost every time by the accused. So you have to prove each of the elements of the self-defense for it to successfully claim such defense. The defense includes, as again, defense of life, property, honor, or rights. Now, with regard to defense of property, the Supreme Court recognized Articles 536 and 539 of which, like Article 49 of the Civil Code, allow the reasonable defense by emphasis the respect to be accorded to the owner or possessor of property without requiring some simultaneous attack on his person. This is the person who in possession of a property has the right to defend against anyone who tried to dispossess him or tried to trespass into his property. Basically that provision. So the Supreme Court states that in order to successfully claim this defense of property, there is no requirements with regard to simultaneous attack on the person possessing the property. If the act of the victim falls under Article 429, 536, and 539 of the Civil Code of the Philippines, he may use the reasonable necessity of means or the reasonable necessity of the means employed to prevent dispossession, prevent trespassing, prevent him from lawfully exercising his right over the property. Now, some points on unlawful aggression. Unlawful aggression by the victim against the accused is the primordial element for the right of the latter to invoke self-defense or defense of his honor, property, or rights. Now, unlawful aggression. Unlawful aggression is a paramount or important element in self-defense. Lawful aggression must be actual, evident, and not only imaginary. Now, with regard to reasonable requirement, the reasonableness, the Supreme Court held that the reasonableness of the means employed may take into account the weapons, the physical condition of the parties, and other circumstances showing that there is rational equivalence between the means of the attack and the defense. The test is whether they are commensurate as they appear to be one making the defense. Now, if for example, if you are attacked by a 6-foot muscular man will you able to, and you are like a 4 feet really thin person, would it be reasonable for you to use a firearm if you are unlawfully attacked by a muscular 6 foot man? The possibility of death is imminent, of course, if you are 4 feet and thin person. Now, is the use of firearm actionable under the circumstances if it is the only means to prevent or repel the attack? It's reasonable. You cannot run and then find any less dangerous or fatal means to prevent the attack if the firearm is already in your possession, at your disposal. You cannot go further and seek for any less fatal means to repel or prevent the attack. Now we have this in People versus Haureki. The means employed by the offended girl using a knife to prevent lascivious act being committed against her by a man may be considered reasonable. But under the circumstances, it was the act or the lascivious act committed in the chapel where there are also people in attendance. The accused was or the defense of the accused in stabbing the man who commit lascivious conduct against her person was deemed to be unreasonable because, as again, the crime was committed in the chapel where persons or other person where the other person's present, and she could have called the attention of other church or chapel goers. So it will depend on the circumstances, the reasonable means. Say for example, if the woman victim of lascivious conduct was alone with the person who is committing the lascivious conduct, then the use of knife or firearm is or may be reasonable under these circumstances. In People versus Hinosa, well, our criminal justice system introduced battered woman syndrome. What is battered woman syndrome? The alleged characteristics of this syndrome are: the woman believes that the violence was her fault. She was unable to place the responsibility for violence elsewhere. She fears for her life and or her children's lives. She has irrational belief that abuser is omnipresent and omniscient. Now, this is a novel case, People versus Hinosa, because at the time of the killing of the husband, the wife was not physically attacked. Now, the Supreme Court uh, introduced this novel theory of battered woman syndrome as postulated being equivalent to self-defense. Now, the accused in this case was convicted for parricide for admittedly killing her husband with treachery in 1995 and sentenced to death in 1998. He appealed. She appealed. Sorry. She contended that she acted under the effects of battered woman syndrome, a concept of self-defense in the United States. Now, that battered woman syndrome is reportedly classified as post-traumatic stress disorder, that's PTSD, brought about by constant and violent physical beatings and the abuse by her husband, on which there was testimonial evidence. Now, as I've said, the characteristics of syndrome are: the woman believes that the violence was her fault. She was unable to place the responsibility for the violence elsewhere, and she, she fears for her life or the life of her children. She has a rational belief that the abuser is omnipresent and omniscient. Now, this concept is now set forth adequately under RA 9262, the Anti-Violence Against Women and Their Children, so that in case the People versus Hinosa case is rendered more than academic at present, because of the law which address violence against women. We'll continue later.